Welcome. This is James Corbett with your eye-opener report from BoilingFrogsPost.com. And now for the real news. A recent court case in Utah has uncovered yet more evidence that the FBI is hiding key documents from the public by placing them in a separate, hitherto unknown electronic storage medium known as an S drive. The fact that this drive was previously unknown has raised the specter that the FBI are using it as a place to hide requests for sensitive documents through the Freedom of Information Act. Now, a federal judge has given the FBI until the end of the month to explain what the S drive is, how it is being used, and whether it contains key documents related to the case in question. The case concerns Salt Lake City-based lawyer Jesse Trentadue, who has been investigating the death of his brother Kenneth Trentadue at an Oklahoma federal transfer facility in 1995. The government has maintained his brother's death was a suicide by hanging, despite the fact that his brutalized corpse revealed him to have been beaten to death, with cuts and bruises all over his body. Numerous irregularities in the wake of Trentadue's death were suggestive of a cover-up, from the government's unprecedented offer to cremate the body before it was sent to the family at its own expense, to the fact that the coroner was not allowed to examine the cell until it had been washed, to the fact that the visitor logs from the facility on the night of the death have been destroyed. Subsequent investigations uncovered leaked documents showing that the cover-up went all the way up the chain of command to Eric Holder, currently Obama's Attorney General. Originally baffled by the extent of the cover-up, several tips, including one from Timothy McVeigh himself, led Jesse Trentadue to the understanding that his brother had been transferred to an Oklahoma transfer facility because he fit the description of the so-called John Doe No. 2 in the Oklahoma City bombing case. Since that time, Trentadue has been suing the FBI to try to pry more information about the OKC investigation from the agency's vaults. Among the documents he is pursuing are the surveillance tapes from the Murrah building itself, which were being stored off-site and thus were not damaged in the blast. These tapes, which sources connected to the investigation have told the LA Times and other major media outlets that they have seen, are purported to show the approach of the Ryder truck to the building and also show Timothy McVeigh's accomplice getting out of the truck. Under the Freedom of Information Act, the FBI is not required to say if a document exists, only that they searched their database and found no records responsive to the request. If these documents are placed in an external or disconnected storage drive, however, the agency can ensure that they will never show up in any FOIA request. In fact, the FBI has been known to have used this very technique in the past. Going under such names as June Files, Zero Files, and iDrive, the agency has a long and documented history of placing key evidence in special, compartmentalized files that are reviewed by senior officials before the information is placed into the Bureau's official files. Joining me earlier this week to discuss the history and significance of the FBI's secret storage drives was attorney Jesse Trentadue.
It's important to know that in most matters, the FBI opens what's called an official file. And if someone is under investigation for a crime and eventually charged with a crime, the official file is supposed to contain all of the evidence, both incriminating evidence and exculpatory evidence. And this file is turned over to defense counsel. Also, when someone files a Freedom of Information Act request, it is the official file the FBI searches for records and documents to produce. Starting, and I'm sure it existed before this time, but I learned during the course of this fight that during the 1970s and 1980s, the FBI had what was called a June file, and I don't June, and I don't know if that's an acronym for something, another name or whatever, but the June file was where they placed evidence and other materials and information they did not want to disclose to defense counsel in criminal cases or make public through a Freedom of Information Act request. The June files came to light in the late 1980s as a result of a Freedom of Information Act lawsuit. I next found and uncovered the fact that after the June files were revealed, the FBI implemented another evidence hiding system called the Zero files, ZERO, and this served the same function. Information, evidence, documents, other materials that the FBI did not want to turn over to defense counsel in criminal cases or make public through a Freedom of Information Act request went into the zero file and just disappeared. And so if you filed a Freedom of Information Act request, the FBI would look at the official file and come back and report there was nothing there that you might be searching for if it was this type of information. After the zero files were revealed, I found out that, and as a result of my lawsuit, that they implemented, the FBI implemented a new system called the iDrive. And it served the same function as the June files 2 decades ago, the zero files a decade ago, and the iDrive was implemented apparently in the late 1990s and into the 21st century. So we're in court, and I am arguing the fact that the FBI has this elaborate system, a continuing, evolving, living system almost for hiding the truth, hiding evidence, hiding embarrassing information, or whatever it is that they do not want the public or defense counsel to see in criminal cases. And so I reached the point of the iDrive, and suddenly the attorney for the FBI interrupts and advises the court that the iDrive is irrelevant. And the judge says, why? And the attorney says, because we've replaced it with the S drive. And that caused all kinds of commotion in the courtroom, because that, to my knowledge, is the first time there's been a public acknowledgement by the FBI that they do now have an S drive. And part of the order the judge issued is by June 30th of this year, the FBI has to also report back to him the function of the iDrive and S drive and whatever other drives they have out there that may be used or are being used to conceal.
Critics of the FBI have long noted how the Bureau under J. Edgar Hoover's leadership sanitized files to hide potentially embarrassing information about the FBI and its agents from the public. In a conversation with the Corbett Report last week, Colleen Rowley, the former Privacy Act coordinator at the Minneapolis FBI field office and noted FBI whistleblower, confirmed the sordid history of the FBI's attempts to conceal information from the public, and revealed other methods that keep key records from being accessed through FOIA requests.
The commentators who are dredging up this history of J. Edgar Hoover and always wanting to sanitize the files before a case would go to court are absolutely correct. We had a huge scandal with the Timothy McVeigh prosecution in Oakbaum, and that case came about, the scandal came about actually in the summer of 2001, right before the 9/11 attacks. That came about because in that case they had gone to this new, more open discovery, but that's not the FBI's normal procedures. Normally, the commentators are totally correct. The FBI had the idea that non-relevant information would not be provided. And certainly this is embarrassing in FOIA cases. I mean, by law they're required to give out an entire file. Well, one of the ways to get around not giving out an entire file afterwards, let's say you identified several wrong suspects, and you can see this in the high-profile cases of the anthrax killer, where they had to pay $5 million to somebody for being Hatfill, for being identified as a suspect. The Richard Jewell case in the Atlanta bombing. So those cases where they have identified even completely wrong persons, it's embarrassing afterwards to give out all that information. So the FBI tries to find ways to file documents so that they're not considered relevant. And I don't know the whole context of these iDrives and S drives where there's been different information, but I know that's consistent with past track record of putting information into control files that so it does not pertain to an actual case classification. And the other thing, that, of course, that the FBI does in Freedom of Information is they have a very antiquated system that's not consistent with word searching capabilities. So if somebody asked about a case, they actually go on the old-fashioned notion that the name that you're asking for has to be in the title of the case, as opposed to just doing a word search. There's all kinds of things that they've never really been called on, and freedom of information activists really do need to pursue this, because the FBI's compliance needs to be brought up to date instead of, still back in the old J. Edgar Hoover era.
Spokespersons for the Bureau have so far refused to comment to the press about the S-Drive story, citing the ongoing litigation. The court order requires them to present a full explanation of the use of these document storage systems to federal court by June 30th. For more on this story, stay tuned to boilingfrogspost.com and corbettreport.com. This video is part of a new weekly video news series. Future editions of this series will be available to subscribers of boilingfrogspost.com. For more news and commentary from James Corbett, please visit corbettreport.com.